A lawsuit has been filed against a city in Michigan and several of its police officers by a black father, his son, and their black real estate agent after they say they were wrongfully arrested while house hunting in August. Real estate agent Eric Brown was showing his clients Roy and Samuel Thorne a home in Wyoming, Michigan when police arrived outside, surrounding the house, drawing their guns, and ordering the three to exit the home with their hands above their head, then handcuff them. A neighbor had called the cops saying one of the men looked like the same person police arrested a week earlier for unlawfully entering the home, except the neighbor was very wrong. The men were released after Brown showed the officers his real estate license. Now they're suing the city of Wyoming, the police chief, and the 6 officers involved, claiming their civil rights were violated. Here to discuss this story and several others is veteran prosecutor and BNC's legal contributor, Paul Henderson. All right, Paul. These men are seeking damages, accusing the officers of unlawful detainment, using excessive force, and intentionally inflicting emotional distress, among other claims. But the police department describes this incident as, quote, an unfortunate misunderstanding. Your take?
Okay. So, all right. Here's the thing. That unfortunate misunderstanding is not their suffering. And these are experiences that communities of color have and experience regularly when interacting with law enforcement. And it's insulting to have that approach. It's insulting to have that perspective communicated from the department, which is a reflection completely that they are insensitive to the treatment by communities of color specifically, and those victims by that department. Let's just start with that. Now, moving on to what they're asking for with these damages is not enough. Those damages are fine for civil accountability, but what I want is for there to be an evaluation for criminal consideration, and for what I want is some administrative consideration as well to make sure that this isn't happening again, as it has happened in the past, as we all know has happened in many communities throughout this country, and now it's happening here. And once again, it's caught on video, and we're having an awkward conversation, awkward for law enforcement, to try and justify bad behavior and race disparate treatment for communities of color that are again being called into question for hiking, for walking, for bird walking, for looking at houses, for coughing, for having a barbecue, drinking water, and the list goes on. It's insulting that we keep having these same conversations, but it's a sign of the action that we have to take in order to make sure that departments have policies to address the concerns for communities of color, because we get to define public safety as well. It's our tax dollars that define how law enforcement interacts in our communities, and treatment like this, it has to stop. It's inappropriate at best and needs to be accountable in this situation as it does in the other situations as well, Yodit.
Well, the city of Wyoming, the police chief, and the 6 officers involved are all named as defendants in this lawsuit. Does qualified immunity come into play for the officers?
It does at some levels, and good that they're all named. You know who else needs to be identified there? The lawsuit? The neighbor that called in. So put them in that lawsuit and let that person indemnify themselves for this terrible treatment as well. But let's just start with the department and those officers. Yes, this is exactly the kind of case where they would be shielded from being accountable as long as they were reasonably carrying out their duties. And here's the thing, because it goes beyond just the legal standard, which I just explained, but the real issue is the intransigent and the subjective determination that cops are allowed to exercise while they are doing their job. This is the real problem. And so while it is allowed, it's inappropriate. And this is before we even start looking at race disparate treatment for how they would have treated or how they have treated other communities and other individuals in the same situation. That's the core of this problem. This is why the immunity itself is being challenged in the George Floyd bill, which is stalled right now over this exact issue, because the Republican Party and many others don't want to remove the cover and the shield that officers have to engage in subjectively determined behavior exactly like this. And it's a cyclical argument but this is exactly why we are having the problems that we are having. So presumably, if we are able to remove the shield, we are able to have the officers be held more accountable for their subjective decisions that elevate encounters into detentions, that elevate encounters into use of force, that elevate encounters into arrests that later turn out to be false or inappropriate, and again, race disparate.
All right, let's go to another story. This weekend, a federal judge gave permission to a white man facing charges for his role in the January 6th insurrection at the U.S. Capitol, gave him permission to travel to a Pittsburgh game, a Steelers and Broncos game, okay? Now, as a defense attorney, I can't even imagine asking a judge on behalf of a black client about letting them go to a game. I mean, there are people of color on bail who can't go to once-in-a-lifetime events like funerals for family members. This is just another example, Paul, of the two legal systems we know exist for white people and black folk, but does it also show how some aren't really taking what happened on January 6th seriously?
Yodit, now see how you started me off with irritation, and now you are leading me to frustration. So let me just tell you about this case, because two things. I think that was bold to file a request like that while pending criminal charges, but then also frustrating to not have prosecutors oppose that representation at all and allow for something like this to happen while someone was facing these criminal charges and these criminal counts. And let's keep in mind, this isn't the first time that we have seen an outrageous request with the insurrection defendants, because we saw it earlier in this year in February when we saw someone made a request so that they could go on vacation while their criminal charges were pending. I haven't seen requests like that. In many cases, the fact that it's taking place in the federal courts, and in this case where democracy itself was being challenged and attacked by the presence and by the conduct of these people, is an insult. But let me tell you where the real insult comes. The real insult comes from one of the victims in this case. There's an officer of color that was talking about this in particular, saying that he was frustrated and angry about it because he was injured in that insurrection and he couldn't have gone on vacation. And so that, to me, shines the light back on prosecutors in this case, that even if you weren't going to oppose it, I feel like you had an obligation to inquire from some of the victims and input victim statements as to what their feelings were before you allowed the judge to rule in however way he was going to rule.
Oh, they agreed, Paul.
Yeah. I mean,
just to let you know, they agreed. Prosecution agreed.
Oh, I know. That's what I'm saying. They agreed without submitting any of this stuff in opposition to the request. That's part of the frustration. And let's keep in mind, just to give all of this context, is that after the George Floyd interactions and the rallies that were had and the peaceful protests that were had all over the place, and in some places there were riots, this country came back with over 90 anti-riot bills introduced all over the country to avoid and challenge that behavior. And this does not seem to be the same type of approach, and it certainly doesn't seem to be the same type of outcome when we're considering it for what these charges are, which is another protest rally and exactly the definition of a riot.
Paul, I want to get into the last topic before we go. R. Kelly, yet again. Rolling Stone is reporting that his music sales have increased by double digits since he was convicted for sex trafficking and racketeering. What do you make of that?
Now, ain't that some ish? Because really what's going on is when you are mentioning his name and people are thinking about R. Kelly and playing his video more and playing his music more, the issue to me is, where's that money going to go? Now, I believe that he is bankrupt at this point in time, and there's an actual argument to be made about whether or not the dollars that are coming to R. Kelly from his music, where it's actually going to go. And the argument to be made is that maybe that money is for the victims of his cases that are waiting in line to be repaid for their damages. Now, that assessment is going to take place in the latest case that he just got his guilty conviction of, but that won't be for a number of months. That money will go towards helping their healing, their treatment, and all of their damages before the civil lawsuits conclude that he's still facing.
All right, veteran prosecutor and legal contributor Paul Henderson, thank you so much for your brilliance, sir.